Union territories. Introduction. Union territories refer to areas directly administered by the central government. Their administration is the responsibility of the president, who administers them through administrators. At present, there are seven union territories: Andaman and Nicobar Islands, Chandigarh, Dadra and Nagar Haveli, Delhi, National Capital Territory, Daman and Diu, Lakshadweep, and Pondicherry. These areas have been placed under the direct control of the central government for different reasons such as cultural distinctiveness, strategic importance, or due to political and administrative considerations. Administration. There is no uniform system of administration in the union territories. Parliament has been vested with the power to prescribe the structure of administration in the various union territories. The administrators of union territories are variously known as lieutenant governors, chief commissioners, or administrators. In Daman and Diu and Pondicherry, they are designated as lieutenant governor. In Andaman and Nicobar Island and Chandigarh, they are known as chief commissioners, and in Lakshadweep as administrators. Similarly, some union territories possess legislative assemblies and councils of ministers, such as Daman and Diu, Pondicherry, and Delhi. National Capital Territory, while others do not. Before the creation of Legislative Assembly in Delhi, it had a Metropolitan Council and an Executive Council. The 68th Amendment, carried out in 1992, provided a special status to the Union Territory of Delhi. It redesignated the Union Territory of Delhi as the National Capital Territory of Delhi and stipulated that the administrator shall be designated as the Lieutenant Governor. The Amendment Act created a legislative assembly for the National Capital Territory of Delhi and granted it power to make laws for the whole or part of the National Capital Territory with respect to all matters enumerated in the state list or concurrent list, except with respect to entries 1, 2, and 18 of the list. It also provided a council of ministers consisting of not more than 7 members, with the chief minister as its head to aid and advise the lieutenant governor in the exercise of his functions. It may be noted that in union territories with legislative assemblies, the right to legislate on subjects enumerated, the state list and the concurrent list vests with the assembly. With respect to the other union territories, the laws are enacted by the parliament. The administrators of the union territories enjoy the right to issue ordinance within certain limitations. When the legislature of the union territories are dissolved or suspended, responsibility for the peace, progress, and good government of the territory falls on the president. Scheduled areas. The Constitution has made special provisions for the administration of the scheduled areas in a state other than Assam, Meghalaya, Tripura, and Mizoram. The right to declare any area as a scheduled area rests with the President and is subject to legislation by the Parliament. The Constitution contains special provisions regarding the administration of the scheduled areas, which are contained in the fifth schedule. The Union government can also give directions to the respective states regarding administration of the scheduled areas. The governor of the state where such areas are located has to submit reports to the president regarding the administration of such areas annually or whenever required by the president. To take care of the welfare and advancement of scheduled tribes in the state, a tribes advisory council is constituted. In addition, the governor can also take certain steps to protect the interests of the scheduled tribes. Thus, he can direct that a particular act of parliament or state legislature shall not apply to the scheduled areas. He can make regulations prohibiting or restricting transfer of land, allotment of land, and money lending. However, all these actions of the governor need prior approval of the president. The tribal areas. These are located in the states of Assam, Meghalaya, Mizoram, and Tripura and are specified in the sixth schedule of the Constitution. Though these areas fall within the executive authority of the state, provision has been made for the creation of district councils and regional councils for the exercise of certain legislative and judicial powers in these areas. The district and regional councils are empowered to make laws in certain fields such as management of forest, marriage and social customs, inheritance of property, etc. These councils can also impose certain taxes and collect land revenue. The governor can also authorize these councils to try certain suits and offences. Federalism in India, Union States relation. Federalism in India on the basis of relations between the central government and Federating units, the governments are classified as unitary and federal. In a unitary system of government, all powers are concentrated in the center, which can delegate them to the units. On the other hand, in a federal system, powers are divided between the center and the states through the provision of the Constitution. The Constitution of India provides for a federal system of government in the country, even though it describes India as a union of states. The term union of states implies firstly the Indian Federation is not a result of an agreement between independent units, and secondly the units of Indian Federation cannot seen from the Federation. The Indian Constitution contains both federal and non-federal features. Federal features in India. The federal features in the Constitution of India include a written constitution which defines the structure, organization, and powers of the central as well as state governments. Supremacy of the constitution, which implies that both the center and the state governments are subordinate to the constitution and are expected to function according to its provisions. A rigid constitution can be amended only through a special procedure which is quite different from the ordinary lawmaking procedure. Some provisions of the constitution can be amended only with the consent of legislatures of not less than one half of the states. An independent judiciary which acts as the guardian of the constitution and ensures that the center and the states operate within their respective spheres. It also acts as the guardian of the fundamental rights of the citizens. A clear division of powers between the center and the states, the powers which are of national importance in which a uniform policy is desirable in the interest of the nation, have been entrusted to the center, while matters of the local concern have been allocated to the states, and the creation of an upper house, Rajya Sabha, in which the states have been given representation. The scholars' view about the Indian Federation are: modern constitution says that India has quasi-federal system, a unitary state with federal features. K. Santhanam, Union States Relation in India, says that the Indian Federation has two peculiar unitary features. The Union government has more financial powers, and the Union government controls the states and development projects through the Planning Commission. Paul Appleby, public administration characterizes the Indian system as extremely federal, while Jennings, some characteristics of the Indian constitution describe the Indian system as mainly federal with unique safeguards for enforcing national unity and growth. Alexandrov's Constitutional Development in India says that India's federal case is unique in character, while Granular Austin, the Indian Constitution, cornerstone of a nation, describes India as a cooperative federation. Unitary features in India. Indian Federation is asymmetric in the sense that its units are unequal on the one hand, and the union government is more powerful than the states on the other. This is evident from the following. At the time of attaining independence, the federating Indian units were extremely unequal, classified into states A, B, C, and D. The units were not equal in any respect. The reorganization of the states in 1956 into 14 states had only one equality among them. They were linguistically formed from 14 states to the present 28 states, demonstrate numerous asymmetrical tendencies. The state of Jammu and Kashmir has an advantage over other states. Under Article 370, it has its own constitution. No other states of the Union of India has its own constitution. Article 371 has special provision, facilities for the northeastern states of Arunachal Pradesh, Assam, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Tripura. Some states are too small: Sikkim, Nagaland, Meghalaya, Tripura, and the like, while some other states are too large: Uttar Pradesh, Madhya Pradesh, Maharashtra, Rajasthan, both in population as well as in territories. Some states are financially and resources wise better than other states. Maharashtra, Gujarat, Punjab, Haryana are high income states, while Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Bengal are middle income states, whereas Bihar, Jharkhand, Uttarakhand, Orissa are the low-income states. The federating units in India do not have equal representation in the Council of States. See Schedule 4 of the Constitution. Thus, we see that the federating units are not equal in relation to each other. Now, nor are they considered equal by the federal government individually as well as collectively. This can be substantiated from the following. Article 3 of the Constitution empowers the Parliament to create new states, alter their boundaries, and even their names. This indicates the unitary tendency. The states in India do not initiate the amendment proposals. It is the power of the Parliament, the national legislatures. See Article 368. The states have the power to ratify the amendment proposals. The required ratification is no more than half of the number of states. If the Union government can manage to take along with it some minor half of the states, it can get away with any amendment. See Article 368. The states participate only in amendment of a few provisions of the Constitution, only those contained in Article 368 and not in all the provisions of the Constitution. The single judicial structure provides the Union government more importance. The Supreme Court is not only the highest court but is also the court which controls all the subordinate courts, including the high courts. There is no uniformity of representation of the states in the Council of States. The states are represented in the Council of States on the basis of their population. See Schedule 4. The Union government has more subjects to make laws on. It can legislate on the Union list 97 subjects in the original Constitution, while the states legislate on the subjects in the state list 66 subjects in the original Constitution. On the concurrent list, which had 47 subjects in the original Constitution, both the Union and the states can legislate. In case both the governments make a law on any subject of the concurrent list, the Union law prevails over the state law to the extent it goes contrary to the Union law. The Parliament is empowered to make laws on the state list. In certain circumstances, during emergencies, when states themselves request the Parliament to make such laws, when any international treaty is to be implemented, and when the Council of the State declares any state list subject as of national importance, see Articles 249, 250, 252, 253. The governor of the state is appointed by the President and can be recalled or removed by the President and remain in office during the pleasure of the President. See Articles 155, 156. The governor is empowered to reserve any bill for the consideration of the President, who can withhold his/her assent to such bills. Article 201. The directives from the Union government flow to the states. Article 256, and not the vice versa. The states have to ensure the compliance of such directives if they have to avoid action taking over consideration of the state under Article 365. The Union government has more financial powers than those with the states. The states have to depend on the Union government for financial assistance. Article 273, 275. Planning Commission, which is virtually the highest body in planning matters, is under the control of the Union government. The states have to look to the Union government for favor of development projects. Single citizenship, that is the Indian citizenship, and numerous other measures such as uniformity in administration, all India services, all these go to favor the Union government. And yet Dr. B.R. Ambedkar has said that India a federal state insofar as the Constitution provides a dual polity. The states have not been created by the national government. The states derive the authority and power from the Constitution. The Constitution has given the states a list of subjects over which it is empowered to make laws. The Constitution demands the existence of the government in the state. Article 154, and also the State Council of Ministers headed by the Chief Minister. Article 163. Union States relation. The federal adopted in India involves division of the authority between the Union and the states. Both the centre and the state derive authority from the Constitution, and each is sovereign within the field assigned to it. In fact, the authority of one is coordinate with that of the other. Relation between the Union and the states can be studied under the following heads: legislative relations.